What's up, everybody? And welcome into another Chad Daybell update where we get potentially the defense's best and most important evidence through an expert and some attorney sanctions we've been waiting on. How much and when does he have to pay? So all that and more on today's video. We're going to break down day 27, get into the judge's order, answer all of your questions, and take a look at your comments. I appreciate you guys joining me. Let's get into it. So we knew that the defense was going to have a medical expert come in and testify about the cause of death for Tammy Daybell. He already had a state witness, the coroner, say it was a natural causes or unidentified death, not homicide. And then, of course, that was changed. But that evidence was presented before the jury. And now the defense is going to present another medical expert who says basically the same thing. Can't tell really what the bruises are from. They're non-specific. It's an unidentified death. It shouldn't have been ruled a homicide. Shouldn't have been ruled death by asphyxia. That could be a potential reason. It's just as likely that there were a bunch of other reasons. They talked about seizures. They talked about all the defenses, and it basically went how they needed it to go. But I thought the prosecutor did a pretty good job on cross-examination picking that apart. And I thought one of the most interesting things about it was the line of questioning where the prosecutor, Lindsay Blake, starts going through all of the things that this medical expert had not reviewed. And we'll figure out why, because John Pryor objects and Lindsay Blake gets a chance to explain in front of the jury why all of these things are relevant and why she's asking these questions, which if not for the objection, it may never come out. And the jury could have been sitting there thinking, why is she asking if this expert has reviewed all these documents? And it's also important because all these documents are things that the jury is going to consider. Some of them they're going to have to review. Some of them people have already commented on. So if this expert doesn't have what the jury's reviewing, that's important, right? Because the jury has to make this ultimate decision, but that's not all. And there's a lot of documents that this expert didn't review. So let's take a listen as Lindsay Blake goes through a slew of them.
And you said maybe since then you've reviewed a few more documents?
Yes, I believe so. But if that was 3 years ago, so I believe a few things have come through. When I started first reviewing them, a few things have come through since.
And do you recall what those things are that have come through?
I believe it was just, I believe it was different reports of what the coroner reported on. I don't recall specifically, I'm sorry.
As part of your, and let me back up, and these were documents that were provided to you by defense counsel?
That's correct.
So when you say you reviewed the autopsy report and other pertinent information, it was the defense that provided you that other pertinent information, is that correct?
The defense provided me everything, yes.
Did you
As
review?
usual, is the defense provided me everything they wanted me to review, but Lindsay Blake's going to go through all the stuff they didn't provide her. And I'm sure in closing arguments going to connect why they think the defense did not provide her with all these extra documents.
A report from Lieutenant Powell regarding requesting Walmart records?
That does not sound familiar, but I don't remember.
Did you review a report of an interview with Emily Daybell?
I don't recall.
Did you review a report of an interview with Paul Daybell?
I don't recall.
Did you review a report of an interview with Jana Penrose?
I don't recall. Seems like I didn't review it, or I don't recall reviewing it, meaning it wasn't important in her forming her expert opinion.
Relative of Tammy Daybell?
I don't believe so.
Did you review a report of an interview with David Warwick?
I don't believe so. The name's not familiar.
And you said you reviewed some of the coroner reports. Would that be Brenda Dye? Does that name sound familiar?
It does sound familiar. Like I said, one was not signed. I didn't know who wrote it, but that name does sound familiar.
Did you review an interview that was conducted with Brenda Dye, a report of that?
I believe so, yes.
Did you review a report of an interview conducted with the deputy coroner, Tammy Wilmore?
Yes, I believe so.
Did you review a report that contained some records from a Lolly Time iCloud account?
No.
Did you review a report from Benjamin Dean, an analyst with the FBI?
No.
Did you review the Seasons medical records?
No.
Did you review the Teton medical records?
No.
And I think you indicated you did review some reports of the October 9th incident.
Yes.
And that would have been regarding an attempted shooting of Tammy Daybell. Does that sound familiar?
Yes.
Did you review a report of an interview with Matthew and Regan Price?
I don't believe so.
Did you review a report of an interview with Haley Palmer?
No.
Did you review any reports of interviews with Angela Yancey?
No.
Did you review a report of an interview with Ronald and Phyllis Douglas?
Judge, I'm going to object at this point to the relevance of how that would have an impact on the autopsy. She's going to go down a list of every report that any witness in this case discussed.
No speaking objections.
So I think Pryor thought he was getting one over by having the speaking objection, letting the jury know none of this stuff is relevant. None of this matters that she hasn't testified to this. This is something you handle on redirect, right? And if he would have just handled it on redirect, maybe he would have gotten away with it a little bit better. But making this speaking objection in front of the jury, Judge Boyce was not happy about that. And then he lets Lindsey Blake respond.
Please, but I'll sustain the objection at this point unless there's some specific relevance to the autopsy.
And if I may
He's like, I'm going to sustain it. Oh, but wait, Lindsey Blake has an argument.
respond.
Go ahead.
I'm reading off a list that was reviewed by the Utah medical examiners in making their findings. I
Okay.
think it is relevant.
All right. If that's the foundation for that, I'll allow that to continue. Thank you, Ms. Blake.
Boyce was going to sustain it. Again, I think Boyce has been pretty fair throughout this whole trial to both sides. And right there, he was like, yeah, that makes sense. I don't know what the relevance is because you probably should have maybe laid it first, but I think this landed even better for Lindsey Blake as kind of a home run or a knockout punch where it's like, oh, why is this relevant? Well, when the medical examiner in Utah was making their actual correct homicide by asphyxiation determination, they reviewed all of this. So they found it relevant. If she didn't want to read it, she didn't have to. The defense can give her whatever she wants. Whew. Not great for the defense there, but there's even more that she hasn't reviewed that now the jury knows, the judge thinks is relevant, and the Utah medical examiner felt it was relevant, and all of these things, all these statements, all these documents, all these reports from Daybells and Warwicks and all these people that we've heard from in this case, the jury also has to look at all that in context and making their decision as to what was the cause of death for Tammy Daybell. And while they're not medical experts, if they think the cause of death was not a homicide, then we don't have a criminal case here. So they do, at the end of the day, have to determine whether or not this was a homicide.
Did you review a report of an interview with Ronald and Phyllis Douglas?
No.
Did you review a report of an interview with Lisa Jensen?
No.
Did you review a report of an interview with Janet Davis?
No.
Did you review a report of an interview with Melissa Coles?
No.
Did you review a report of an interview with Mary Fran Jepson?
No.
Did you review a report of an interview with Faye Harris?
No.
Did you review a report of an interview with John Ox?
No.
Did you review a report of an interview with Margaret Brown?
No.
Did you review a report of an interview with Stephanie Peralta?
No.
Did you review a report of an interview with Angela Johansson?
No.
Did you review a report of an interview with Shanna Miller?
I don't recall.
Did you review a report of an interview with Barbara Blair?
I don't believe so.
Did you review a report of an interview with Hannah Munoz?
No.
Did you review a report of an interview with Britt and Crystal Briggs?
No.
Did you review a report of an interview with Micaiah Bakeland?
No.
Did you review a report of an interview with Cara and Sandra Briggs?
No.
Did you review a report of an interview with Emma Moss?
No.
Did you review a statement given by Greg Stoddard?
I don't recall.
Did you review 4 to 5 reports regarding insurance surrounding Tammy Daybell life insurance?
No.
Did you review a report indicating Tammy never used any sick days?
No.
Did you review her Walmart prescription records?
No.
Did you review a report regarding Tammy's cell phone?
No.
Did you review a report? Actually, I'll back up there. So as part of your review of the findings in the autopsy, you did not review the list that was just read off.
No.
Were those documents provided to you?
No.
Meaning defense.
Some of those that were indicated was the medical records. Did you specifically review the Seasons medical records associated with Tammy Daybell
As answered before, I did not.
and the Teton medical records?
Judge asked an answer.
Same.
True at this point. So it's like, you didn't even review the medical records. Now, to be fair, some of those medical records really aren't relevant, in my opinion. Sure, if you want to read every single document in a case, but like somebody's records from 20 years ago are not always relevant to determine something that's happening right now, or the cause of death potentially. They could be relevant, especially when the defense is the one pointing to past anemia and other things that, you know, aren't really recent diagnoses as potential cause of death that could make them relevant. So that's why I think the jury's probably like, yeah, this discredits her testimony quite a bit.
Counsel asked you about reviewing or looking at medical records referencing shaking fits and seizure activity. Did you ever look at any medical records referencing shaking fits?
I don't recall the first question, and I'm not sure exactly what you're asking. I'm sorry. Can you rephrase that?
Did you ever review any medical records associated with Tammy Daybell that referenced shaking fits?
No, I did not.
Did you ever review any medical records associated with Tammy Daybell that referenced seizure activity?
I did not.
Where did that information come from?
That information came from the coroner's report.
And the coroner's report was information obtained from Chad Daybell?
I believe that's where she got it from, but you'd have to ask her. I'm not sure where they got their medical information from.
So, I mean, not great, right? Not great foundation. A lot of experts do things like this, but usually the experts that look at more documents and more statements, usually a jury finds them to be more credible. Now, sometimes they can be more biased. And I think that Pryor kind of has a good line of questioning on redirect that we're going to listen to as well about confirmation bias. But the coroner, I thought, was not great for the state at all, and probably actually kind of good for the defense. The medical examiners, I thought, were really good for the state, not great for the defense. And this witness, I think, was not as great for the defense as they were hoping, because this was supposed to be their most important and best piece of evidence and expert in this case to really hammer home that Tammy Daybell's death was not a homicide.
And you talked about a possible cause of death being cardiac arrhythmia.
It's one possible cause when there's no anatomical findings, yes.
And you said generally with that, you would find a structural defect.
And commonly we do, yes.
In the review of the autopsy report, was there any structural defect with Tammy Daybell's heart?
Not that they found, no.
You were also asked about the bruising on Tammy Daybell, and I think you said you defined it as unspecified or unspecific bruising.
Non-specific. Dr. Christensen testified to that too. They're non-specific bruises.
And counsel proceeded to ask you about putting pressure on someone's chest. Do you recall that?
Yes.
And you indicated you would expect it to be 2 people, at least if that was done?
No, it just takes significant weight to do that. And it's hard to sit on somebody to cause death. And the scientific literature that's out there says probably 450 pounds or more. Actually, it was closer to 600, but they went down to 450.
But you would agree that it could be more than one person involved if that were to happen?
If you have more than one person on you, yes.
I don't find the it could have been, it's possible questions great for the state in any situation. I kind of thought she hammered her credibility. I probably would have cut it off then because I thought that was a really great line of questioning. And she's almost done, but I thought that would have been a good punchline to end on.
And what are the other ways that asphyxiation can be caused or occur?
Well, again, asphyxia is just the process of the body not getting oxygen. So many things. We said drowning already. You're underwater. You're not getting oxygen. Choking. You have airway obstruction. Suffocation. You can be in a position like a car. People have asphyxia where they're underneath a car and the car collapses on them. The pressure on the chest. Asphyxia could be from chemical asphyxia. Such things like cyanide can cause an asphyxial death because it blocks the oxygen getting to the tissues. So the list can go on and on.
And one way to cause asphyxiation could be to place a pillow over someone's head?
You could suffocate them by putting an object or something in front of their face, if that's what you mean.
Yes.
Yes.
One way to suffocate someone could be to put a plastic bag over their head. Would that cause asphyxiation?
Yes.
And as a forensic,
Really, where's the evidence of that? That's the reason I don't love those questions. I think at this point, the story makes sense if it's falling into place, how he acted before and after, comments that he was making before and after. I think you've got him there circumstantially, but to introduce like a pillow or sitting on someone's chest or a plastic bag, I think if I was on the jury, I'd be like, yeah, but you definitely didn't prove that beyond a reasonable doubt. You definitely didn't prove that. So why even bring that stuff up is kind of what I'm thinking, but maybe they want to give the jury, because some jurors like to fill holes that the evidence doesn't give, and maybe they're giving the jury different ways. Well, it could have happened like this. It could have been a plastic bag. Could have been like that. He definitely did it. It could have been all these different ways, but we definitely think he did it. Maybe that's what she's trying to provide.
forensic pathologist, would you agree that you approach an autopsy more like a doctor as you're looking for symptoms, causes?
Well, we are a doctor, so we do look for scientific evidence of a diagnosis. Again, we don't speculate on diagnoses. We say this is a gunshot wound because we have evidence of the gunshot wound. We have hemorrhage. We have a knife wound. So again, yes, we use scientific evidence to base our diagnoses off of, like any doctor does.
And the difference being in an autopsy, your patient can't provide that information, correct?
That's correct.
So you would have to get it from collateral sources?
Pertinent to the cause of death, yes.
If I may have just a moment.
You may.
I have no further questions.
Dr. Raven, Ms. Blake went over a litany of other reports and statements from other witnesses, a variety of other documents. When a forensic pathologist is examining a variety of other documents that are not related to the medical reports and the scientific evidence, is that an example of confirmation bias?
Objection, Your Honor, calls for speculation.
Overruled.
Is that an example of confirmation bias when you take into account all of these other reports, documents, statements of people who were not present at the murder?
Not present at the what? Anybody else catch that? Anybody else catch that? That's not great when you have a little bit of a Freudian slip, but I saw enough people, I will just tell you, enough people reached out to me, commented on it, messaged me, and mentioned that John Pryor said this, that weren't present at the murder, to where I think it is possible a juror or multiple jurors heard it, picked up on it, and would be like, oh, wow, that's a problem. You just admitted that it was murder. But I will tell you from experience in cases like this, one word, one slip up in a multi-week trial that's not highlighted, and they're not sitting there pausing it like I did for this, and we're going to listen to it again. They're not doing that. So it's very possible it went right over their head. They didn't even notice it. Or they picked it up how he was trying to explain it, meaning like in your job, when you're investigating causes of death, homicide or murder is sometimes in the equation. And if somebody's trying to determine this, and they're taking all these statements and outside collateral sources that weren't there at the scene when this happened, that's confirmation bias. That's what he's trying to argue. I don't think he's trying to say, in this case, it was, in fact, a homicide. I don't think that's what he's trying to say. But does that mean a juror won't pick it up like that? And I'm going to back it up so you can listen to it again, exactly how. And again, I think he's kind of feeling himself. He won the objection, and he's like, so isn't this confirmation bias? After he won the objection, he repeats the question, and this time he drops the M-bomb. He didn't do it last time, or the first time he asked the question.
A variety of other documents that are not related to the medical reports and the scientific evidence. Is that an example of confirmation bias?
Objection, Your Honor, calls for speculation.
So he wins it. And instead of just having your answer, he's going to repeat the question even better so the jury can really hear it.
Is that an example of confirmation bias when you take into account all of these other reports, documents, statements of people who were not present at the murder?
Definitely said it. He definitely said it.
So
Let me know what you guys think. I know you're going to already, but would that be a big deal to you if you were on the jury? Is it just a slip of the tongue? Is that, a Freudian slip? Do you think he thinks it is and he's just, being a defense lawyer? Just let me know what your kind of initial thoughts are when Pryor, slips up there and asking that question. I can't wait to read the comments on this one.
and that's a difficult question. We don't honestly look at all those reports on any case really I've ever heard of such an exhaustive list because we don't have those reports available to us. Maybe over a 2-year period we would have them. I don't know, but we don't. Again, we always base it off scientific evidence, what we have in front of us.
So that's not a great answer. I mean, it's a truthful answer, and I think she's credible in being honest, where she's saying most cases we don't have that, but she's saying most cases we don't even have access or the ability to get that. So obviously you're not going to take into account things that you can't get. But in this case, Pryor probably could have turned them over to her, but the defense decided not to. Now, if I was her, the best answer as a defense attorney would have been, you don't need that stuff to make this decision. None of that should or would affect my decision. Now, if that was her answer, that's great. It wasn't really her answer, though.
It's the autopsy. Either we have a cause of death or we don't. We try not to speculate. We try not to guess on what the cause of death is. There's lots of implications to that for anybody. So generally speaking, it is bias. If that's what you're using to determine a cause of death for, that's bias. Either you have a cause of death or you don't. And then again, if we had a case like this where we don't have a cause of death, we do just call it undetermined. And we put that list we've talked about today. These are potential findings, but we don't commit to one of those.
Okay. And to commit to some
Basically,
other
her testimony right there should have been undetermined. You can put other possibilities, but we can't determine it based on the evidence we have or lack thereof.
information like a plastic bag or sitting on someone's chest or putting a pillow over somebody's face. Would you agree that that would be conjecture, speculation, and hunch?
Without any evidence?
Yeah.
Of that? Yes, I believe so.
And at the present
The
time,
problem is that's why I just wouldn't have asked that stuff as a prosecutor. It does open the door for them to be like, they're trying to fill holes they don't have evidence of.
would it be your testimony that the logical conclusion in your mind that should be drawn from this is that the cause of death of Tammy Daybell would be undetermined?
Yes, in my opinion, it should be undetermined.
Judge, I have no other questions. Thank you, Your Honor.
All right.
All right. So there were some other witnesses that testified to for the defense's case that I thought were fine, but nothing really huge. Some witness heard what she thought was a gunshot. We got the rest of John Murray's testimony. I'm trying to think of who else testified. Oh, the officer that interviewed Melanie Gibb testified and basically said that she had all these light and dark teachings and stuff that she knew on her own, and she rated him light. So she was able to do it herself without Chad Daybell. Chad Daybell wasn't the leader, basically. He wasn't the one coming up with this. I don't know if Pryor was trying to say Melanie Gibb was actually the one that was leading it, but it definitely discredited Melanie Gibb's testimony. Problem is, it's all these days and weeks later. So certain parts that were damning for Chad Daybell in Melanie Gibb's testimony, will they still stand? I kind of felt like it was obvious while Melanie Gibb was on the stand, she wasn't being completely forthcoming about, her involvement in the beliefs and wanting to be a leader and, doing certain things and saying certain things. But that doesn't mean that some of the factual things she was testifying to where she was with Chad Daybell and Lori Vallow weren't true. So the jury's going to have to determine that. But I thought that was a good job discrediting her with that witness, because obviously he's not a witness that's going to want to help the defense. But it was good testimony for them. All right, but let's jump to some other things that came out, I think, yesterday or 2 days ago, I guess. Order imposing sanctions. So if you remember back, attorney Terry Ratliff tried to stop this trial from starting. And he filed a motion purporting to intervene in the above captioned case and moving the court for a continuance of the scheduled jury trial. The court ordered Ratliff to show cause, and a hearing took place on April 18th. At the hearing, the court determined that Rule 11 applied to the filed motion and had been violated, requiring the imposition of a sanction. The court determined the appropriate sanction was payment of attorney's fees incurred by the parties in dealing with the motion and requested that the attorneys submit their fees for review. So the judge said, Terry Ratliff, what you did was wrong. Annoying part about this is we can't actually see and read that original motion. I'd love to do that and see exactly what the issue was and all the typographical errors and things the court really highlighted. The court has now received counsel's memorandum of costs. So I think this is interesting, right? What are the fees and costs? What are the differences? How much do you guys think, if you haven't read this yet, how much do you guys think an attorney would have to spend on this? And what do you think is a reasonable attorney fee? Just throw it in there as an hourly rate. I can't wait to see this in the comments. I know it's going to be a wide range. It is Idaho, so we have to take that into consideration. Therefore, the court makes the following additional findings of fact and conclusions of law and order, incorporating by reference the order entered April 22nd relating to this matter. Terry Ratliff is an attorney licensed in Idaho. He filed an error-riddled and frivolous pleading in the above captioned case. He held himself out to be the attorney for the defendant in the caption of the pleading and his signatures on both the pleading and the pleading certificate of service. I guess he didn't really care for or buy the argument that they were just Scrivener's errors or things he forgot to change that were there just on the sample or one that he always uses. Mr. Ratliff is not and has never been the attorney for the defendant in this case. The pleading falsely and materially misrepresented that fact. The pleading filed by Mr. Ratliff required response from the court and counsel for both parties on the eve of a major trial. The pleading caused the parties to unnecessarily divert resources and time in responding and unnecessarily increased the cost of litigation in this case. At the April 18, 2024 hearing, Mr. Ratliff was given a reasonable opportunity to respond and offered no plausible explanation for the misrepresentation that he was the defendant's attorney. He did say that it was just kind of on the sample that he starts with and then, edits around it, and then he just forgot to edit that part. The court determines that the pleading violated Rule 11 and that the rule applies in this criminal case, even though it states in part the quote or case through 47 and 49 that states in part that the court must impose an appropriate sanction, rather than a means for a broad compensatory award for attorney's fees. Rule 11 is a court management tool meant to focus on discrete pleadings, pleading abuses, or other types of litigation misconduct. Here we go. Counsel for the defendant, which would be John Pryor, has submitted documentation that he spent 3 hours addressing the frivolous pleading, including attending the hearing on April 18th. To me, that's more than reasonable. You got to review the pleading, probably have to do some research. You have to respond. You maybe have to talk to the prosecution about it. Tell them you're not involved. Prepare for the hearing. Show up for the hearing. Listen to the hearing. Review documents. So 3 hours, I think, is more than fine, but let me know what you guys think. And he represented this court that his normal hourly rate is $350 an hour. What do you guys think about that? I can't wait to hear what you guys think about it. The court finds that both the time and the hourly rate are reasonable, resulting in attorney's fees of $1,050. The state of Idaho has represented to the court that prosecutors collectively spent 2.75 hours addressing the pleading. So that's always good when both sides spend the same amount of time. Pryor said 3 hours. The prosecutor said 2.75. So that's good. That's reasonable. They have requested fees at the rate of $65 an hour for a total of $178.75. So why the disparity? Well, I don't think it's a surprise that private criminal defense attorneys charge a lot more money than prosecutors. They get paid by private citizens. Prosecutors don't get paid fees. They get paid a salary. And I looked up some salaries. It looks like the range is right around $100,000, maybe more because these might be higher level prosecutors. So that's about $50 an hour. So this might be even higher than what they actually get paid. So how do you determine a reasonable hourly rate? That's one way. What do you actually get paid? Another way, and I think John Pryor does some court-appointed cases, and I shouldn't guarantee. I would be willing to bet the court-appointed fee is less than $350 an hour. But if you charge $350 an hour, if you have clients that regularly pay $350 an hour, if Chad Daybell signed a fee agreement that said he's going to pay $350 an hour, I don't know that he did, But those would all be ways to prove to the court that you charge $350 an hour. The court is also a lawyer. The court has friends. The court knows people. He has colleagues that are in that area. So he knows what's reasonable and customary for hourly rates in the area of Idaho for private criminal defense attorneys. And if he thinks it should be $325 and it's $350, he's not going to quibble over that. And if you want a range, I don't know a single private defense attorney that charges $65 an hour. I have seen private defense attorneys that charge, there are some in New York and probably California that charge $2,000 an hour. There are some in the Tampa Bay area that very customarily and regularly charge and deserve $500, $600, $700, even $1,000 an hour. They work hard. They get really great results. They're the best of the best. They have enough clients where they can't represent everybody. So the clients that really want them, need them, and are willing to pay them the most are the ones that hire them and pay for their services. A lot of times with lawyers, you get what you pay for. So I want to know what you guys think about these numbers. The court finds that the state's request is reasonable as well in both time and hourly rate. In addition, the court determines that a sanction in that amount is appropriate when considering Rule 11. The court has considered whether its own time spent on the pleading should be added as well, and has determined that the sanction of time from both parties suffices as a reasonable and adequate sanction under Rule 11. So the court's like, listen, I'm not even going to hammer you as hard as I could. So the court sanctions Mr. Ratliff in the sum of $1,228.75. That's a very expensive mistake that he made late at night, trying to insert himself in a trial he should not have been taking part in. The court further orders and directs that Mr. Ratliff pay the sanction of $1,050 directly to Attorney Pryor by mail or personal delivery to Mr. Pryor's business address within 30 days of the entry of this order. Mr. Ratliff is further ordered to pay the total of $178.75 to the Office of Fremont County, Idaho prosecutor within 30 days of the entry of the order. Failure to comply with the timely payment of this sanction may be grounds for contempt. And if you don't pay a sanction, the next real big step is probably getting thrown in the slammer. So he has 30 days to pay $1,228.75. Interesting. Not something we see every day in these kinds of cases. I think we've only had sanctions levied against the defense counsel in our cases and in civil cases. I can only think of one or two times. So it's not normal that this happens. Lots of problems happen. You guys see a lot of horrible things happening in court and lawyers being nasty and all this stuff happening, but sanctions are really in the minority of cases, they're not the rule. They're more of the exception, even though there are rules surrounding them. So this was really interesting to see how this took place, and we get to see how it ended up all in one case. And now in 30 days, he's got to pay this sanction for a case he didn't even get paid on or work on. So I thought that was kind of interesting. So let me know in the comments what you guys thought. Please hit that like button and subscribe to our page if you haven't already. We're going to continue following this case. I think it's winding down. I think we're going to have closing arguments soon and then a jury verdict. So hopefully we'll be able to live stream that verdict if you guys want us to. If not, no big deal. Let me know in the comments if you want us to try to jump on immediately when we hear there's a verdict and live stream that and discuss it together and react in real time. But I appreciate you joining me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.